our channel. We bring you an important interim order passed by the Honorable Madras High Court on 7th July 2025 in petition 22949 of 2025. The case touches upon core provisions of Insolvency and Bankruptcy Code 2016, especially Section 16, subsection 2, which deals with the appointment of IRP, Interim Resolution Professional. Let's understand the case, the law, and what the court said point by point. So the background of the case, the petitioner, an insolvency professional, challenged an order of the National Company Law Tribunal Chennai bench dated 4 June 2025. The grievance, what is the grievance? The NCLT had appointed a different IRP instead of appointing IRP proposed by the corporate debtor, that is Unni Traders Private Limited. So corporate debtor proposed IRP, but NCLT appointed a different professional as an IRP, different IRP. So this petitioner alleged violated Section 16, subsection 2 of the IBC and was arbitrary, without authority, and in violation of the natural justice. We'll see the legal provision, Section 10, subsection 3B of IBC. A corporate applicant, while initiating insolvency, must propose an IRP. So Section 16 says no disciplinary proceedings are pending. The IRP proposed in the application under Section 7. Section 7 filed by the financial creditor or 10, Section 10 shall be appointed. Section 10 is application filed by the corporate debtor itself. So Section 16 subsection 2 says that, so if no disciplinary proceedings are pending on the IRP, then in the applications under Section 7 or 10 shall be appointed. Also discussed was about the Section 16 subsection 3, which applies to cases filed by the operational creditors and grants the adjudicating authority some discretion, but only if no IRP is proposed by the operational creditor. So prima facie, the combined reading of Section 10 and Section 16 clearly indicate that the case filed by the financial creditor or corporate debtor, the proposed IRP must be appointed, subject to no disciplinary proceedings. Even in the operational creditor case also, the board can appoint another IRP only when no proposal is made. So therefore, in Section 7, Section 9 or Section 10, the applicant's proposal for IRP is binding. So the finally court said the prima facie it appears that the board is mandated to accept the recommendation of the applicant, whether financial creditor or operational creditor or corporate debtor. The only exception, COC, after formation, can later substitute IRP under Section 22, Section 27. Hence, NCLT was not justified in appointing an IRP different from what was proposed by the corporate debtor at the admission stage. So the direction by the court is, counsel for NCLT was directed to file a detailed counter justifying their deviations, and also asked to bring instances where NCLT appointed a different IRP across the applications under Section 7, 9, 10. The matter is listed for further final hearing, and final opportunity was given to respondents to file their replies. So here the key takeaway is, this case reinforces the fundamental principles of IBC. The IRP proposed by the applicant, whether CD or FC, must be respected unless disciplinary issues are exist. Any deviations without justification can be challenged. We have two channels, RR Corporates and RR Legal Talks. Kindly do subscribe and hit the bell icon so that you will not miss any of the latest updates. Now I will show you the order. This is the order downloaded from website in the High Court of Judication of the Madras, dated 7/7/2025, and the petitioner is an insolvency professional, and these are the respondents, the register of NCLT and corporate debtor and IBBI. These three are the respondents, and the court. This is the prayer. The court explained about relies on Section 10, explained about section 10 and section 16 in detail, and combined reading section 10 3B and 16.2. We can go through this. This is available on the website. This is not the final judgment. This is the interim order in this case. Thank you.